My name is Lesley Benn. I'm the Executive Director of ILSA, and I'm very pleased to welcome you all to the Meet the Compromis Author brunch event sponsored by the Fletcher School of Law. We're very grateful to Fletcher, and I want to thank them on behalf of ILSA and the Jessup competition for sponsoring this event today. I am going to just briefly tell you who's up here. Asaf Lubin is on the far end of the table. And he is the author of the 2016 Jessup Compromis. Next to him is Freddie Sourgens, who is a professor of law at Washburn. Freddie served on the Compromis editorial committee this summer. And next to Freddie is Professor John Cerone, who is from Fletcher. I am now going to introduce you to John Burgess from the Fletcher School. I'm sorry, John, who is going to briefly welcome you. John is the executive director of the LLM program at the Fletcher Law School, and we're very pleased to have John here today as well.
Thank you so much. Thank you. Thanks. It's a real honor for the Fletcher School to sponsor this program, which is a unique element, I think, in moot court competitions, where after all the tormenting and agony of the process itself, you have the opportunity to talk with and perhaps even pose some questions to the author. And it's a unique element of what, of course, is a unique competition. Fletcher is delighted to sponsor the Jessup because the Jessup is a special program that provides the ability to focus on key and developing international issues through a moot court competition across the globe. And your testimony to the range of geographies and commitment and interest in the kind of problems that Jessup poses each year. And it's entirely appropriate because that resonates with Fletcher's mission. Our LLM program is different than most law schools. It's devoted exclusively to international law, a law faculty that teaches nearly 30 courses in different aspects of public and private international law, ranging from everything from transitional justice to regulation of telecommunications as they evolve around the world. But this year's Jessup is unusual in another regard. It has what I consider some of the classic elements of classic Jessup, some nice traditional issues of international law, whether it's extradition or immunity, as always rather tormentingly and nicely balanced for your use over the course of the competition. But it presents some other issues of privacy, of cyber attack, cyber espionage, which are different. These are new legal issues. These are issues that aren't the subject of substantial court rulings, that aren't the subject of decades of academic commentary or detailed regulatory statutory provisions. And that adds an extra layer of, I think, challenge and an extra layer of excitement to this year's competition. Again, that resonates with the LLM program at Fletcher. It's a little different also in that it believes that these kind of issues can't be addressed in a vacuum or in necessarily a traditional law school curriculum. Not for the record that I'm equating vacuums and traditional law school curriculum. I'm simply saying that these kind of issues can best be studied where there's an opportunity to also review issues of international relations, economics, business, technology, diplomatic history. As these problems have to be addressed, new policies evolved, the law extrapolated or created to deal with them. And we very much focus on that in a small program, a program of 15 or 20 students, kept that way deliberately so that there's ample opportunity for research and study on these questions. There's ample opportunity for contact with professors like Professor Cerone, an expert in humanitarian law and human rights law, and the rest of the faculty. But I think this is an appropriate place for me to stop and gracefully retreat from the dais, as we have a variety of very challenging questions and pressing questions to deal with. Is Joseph Kafka going to languish indefinitely in prison? Will the Ames Post be able to recover from the losses it suffered? And if so, from whom? And the question which personally torments me the most is Margaret Mayer's brilliant career in broadcasting to end in a criminal conviction. And to get the answers to those questions and other issues, it's time to turn to the author of their problem and their torment and his colleagues. So thank you very much and enjoy the panel.
I now feel troubled because I'm not sure I have answers to any of these. I need to write the chapter 2 of this to figure the answers to this question. Let me briefly introduce myself and then offer some general commentary and lead it off to the rest of my panelists here today before we'll start accepting your questions, or rather grilling, on this problem. My name is Asaf Lubin. I am a doctoral candidate at Yale Law School. My research is on the international law of espionage and is supervised by Professor Michael Reisman, which many of you have cited in your memorials. I was an intelligence analyst for Israeli intelligence for roughly 4.5 years. I then moved to academia. I did my law degree on law and international relations at Hebrew University of Jerusalem. I then worked for the Turco Public Commission of Inquiry. There was a maritime incident between Israel and Turkey. I was involved in that for 2 years. I lived in The Hague for a little while, and then I worked for the Israeli Ministry of Foreign Affairs, involved in part on our policies concerning administrative and preventative detentions. I will be moving to London in August to begin work as a legal officer for Privacy International, which is an NGO devoted to protecting the right to privacy on the international plane. And I just want to point out to you a few of my individual goals in setting out the journey that I, without realizing I'm going to embark on when I submitted this in February of last year, have embarked on in reality. And there are 3 of these goals. The first is about espionage as a legal field. If before I submitted my application, I looked through past Jessup issues. There's a whole list of them presented on Hein Online. Espionage was not one of those subfields. Part of my dissertation's goal is to produce this is going to sound very bombastic, but to produce the missing textbook on the international law's bookshelf on the international law of espionage. And that is a daunting challenge. If you'll bear with me, I'll quote to you something that I think is very troubling to me. In 2007, long before Snowden, the University of Michigan Law School held a symposium titled State Intelligence Gathering and International Law. One of the speakers was Professor John Redson, former Assistant General Counsel to the CIA, who said the following: "Mortals should not attempt to perform miracles. Caution should precede the expressions from our mouths, pens, and computers, and sometimes we should do no more than stay silent. The trick," Professor Redson said, "is to know what topics we should discuss and what topics we should pass over." He then went on to criticize the symposium's organizer's suggestion regarding the perpetual drive to find, quote, "unity in disorder," and, quote, "is counterproductive at best," he said. "We should accept that espionage is beyond the law," he argued, "resist our impulses and, quote, move to other projects with grace." Part of my dissertation, part of the goals of this year's Jessup problem is to not move to other projects with grace, but rather tackle this project head on. And it is based on a belief, a very deep, sentimental belief that I have, that the world we are in right now cannot continue to move forward in a world where there is a presumption of lawlessness when it comes to intelligence collection and espionage activities. And that is truly the sole purpose of this Jessup problem this year. And it puts in the responsibility on all of you now, because one of the things that is missing, and I'm sure you know this because you've researched this for months now, what is missing is legal scholarship. And what is in a world that is draped with a cloak of secrecy, it is legal scholars who can help pave the way in gradually, slowly, painstakingly develop what the rules of the game should be when it comes to these fields. And that is a responsibility that you have now. Having researched this, you are probably some of the smartest minds on these issues, and I'm sure you have brilliant ideas, go ahead, write notes, write commentary, produce articles. I assure you that I will cite you in my dissertation. So in a way, someone told me that this was just an attempt to crowdsource my research. Probably true. My other goal with this was to create the first Jessup spy novel. I don't know the extent to which I was able to do that. There's all kinds of restraints to the Jessup. But there were a lot of facts that I fought long and hard to keep in this year's case. And I apologize if it turned it to be slightly on the longer side of Jessup compromise problems. I'm sure you didn't enjoy that all that much. But the goal there was really to create a story that was engaging and interesting to read, and to kind of follow through, to realize in the end of the case that Margaret Mary is actually a spy and not just a broadcaster. I thought those kind of twists would make this fun. My final note for this, and I'll gladly and terrifyingly accept your questions soon, is just to say a huge thank you to one person. I had a secret assistant in Israel for drafting this process. I did the huge mistake of writing this alone. I don't know what I was thinking. To be honest, I didn't think that I will get in. That's the real thing. So when I realized that I was selected, I immediately called on a student that was in my team when I coached Hebrew University in 2012. Her name is Shannon Kish. She can't be here because she has just given birth to her second boy. Incidentally, her first boy, Daniel, was born on 26th of March, which is exactly 263 letters sent in the mail with threatening anthrax-like. So this is the kind of the punch in that case. But I just personally want to thank Shannon for all of her assistance in the drafting process of this, and in the long emails I had with the review committee, kind of cooling me down when I read things that I got, why are we not having this, and so on and so forth. So, but I also want to personally thank both the Fletcher School for organizing these events year after year. I think these events are so crucial for students participating. I also want to thank every single member of the review committee. Where I started with this case and where we ended up is a huge difference, and a lot of it is owed to Freddie, who's representing here, but the rest of the members of the review committee, there were around 7 or 8 of them. I see Stephen Schneebaum's here, Dagmar was there. I don't want to list everyone individually, but I do owe them personally a huge thank you in the process of this. And thank all of you for bringing this case to life. You've argued incredibly interesting arguments throughout the week. Part of the drafting of this process, by the way, was to create a question that was not based on a cookie-cutter response. Usually the Jessup has a tendency, when we advance to the advanced rounds, to kind of formulate on a single response that all the teams seem to think is the right answer to the question. And truly one of the motives for me was to develop a question that didn't have a single answer. I wanted to hear creative arguments, predominantly on QPs, on question presented 1 and question presented 4. And we've heard crazy things, from the right to work in the context of cyber activities to international telecommunication laws in the context of espionage. I thought hearing those arguments, regardless of their legal validity, hearing those arguments was extremely thrilling in the advanced round and kept things interesting and engaging throughout the whole process. So really thank you for bringing these countries to life and for making this case real.
Hi, I'm Frédéric Sourgens. I'm here, I guess, in a way to represent a little bit the editorial committee. So what I wanted to do was to give you a bit of a sense of what we do on that committee. A little bit about myself first. I teach at Washburn University School of Law. I'm the associate director of our oil and gas center there. In terms of research interest, I do transnational law, international economic law, and legal theory. But most importantly, I've been a Jessup alum in 2004, and every job that I've had in practice has come from Jessup. So I've practiced international law because I was a Jessup competitor in 2004. So I welcome you to the family and hope that you will find this network really as instrumental to your legal careers as it was to mine. We're all a good family of friends, and you can always reach out to other Jessup alums. In terms of the editorial committee and what we do, it is, imagine that you had 8 or so former Jessupites do to each other what we tend to do to you. So every word, every comma, somebody is going to say, well, but couldn't you make this argument? Well, couldn't you make that argument? And then we have email exchanges up until, what was it, 3 o'clock in the morning?
At least.
That will go back and forth on, no, but there's this argument, no, but there's that argument. And then, you know, some things maintain, stay in the problem, and some things come out. It's usually the ones where we have the most vociferous disagreements with each other that end up staying in, because we see these are actually arguable. These are live issues. These are not the things where it's formulaic, because there are different ways that you can go about it. So what we do is to make sure that, you know, everything maintains that kind of vivacity, but really to also assist Asaf in fulfilling his vision for what he wanted out of the compromise, and serve as a guide to how some issues might be argued about, what might be confusing to teams, and deal with that. In terms of, you know, if you're looking for the kind of things to take to next year, some of the things that we do are help with, well, do all these interlocking cross-references and treaties and statutes actually lead to arguments on both sides that work, and those kind of things. So do pay attention to that. When I judged the rounds, it was frequently the case that people sort of jumped over the language rather than look at the sort of painstaking work that went into, you know, putting all the words and all the commas in all the places. So the one thing that I would say going forward is that is there for a reason, and it's one of the things that we pay an enormous amount of time to make sure that it works. So pick up the cues. And with that, I'm really looking forward to the questions that you might have, and pass it on to John.
Thank you very much. And first, I'd like to thank the organizers in particular for inviting me to join you today. And I beg your indulgence in that I did not coach a team this year, and so I'm not as immersed in the facts and proper names used in the compromise. So forgive me if I referred to the applicant and the respondent rather than their proper names. Oh, and also my compliments, of course, to the author and the editorial committee. It was a real page-turner, I have to say. I did enjoy reading it. I thought I would say a few words about international human rights law, since it's one of my areas of specialty, and then maybe a couple of words on some of the trickier law of state responsibility issues that arise in the context of the compromise. First, for human rights law, I've worked on the issue of extraterritorial application of human rights treaties for some time, and so of course I was interested to see those surface in the compromise this year. As we all know, there's still quite a controversy raging over this issue, and a rather intriguing divergence between the practice of international human rights bodies and the position in the face of significant opposition from some states, but some very vocal states that are opposed to this. Of course, there's going to be citation to regional jurisprudence. The European Court of Human Rights has been fairly progressive on this, but of course we have to bear in mind the difference in treaty language, which I'm sure all of you picked up on in attempting to distinguish ECHR jurisprudence from application of the ICCPR, right? So the European Convention, the obligation in Article 1 to secure rights to everyone within the state party's jurisdiction, no mention of the word territory. ICCPR a little trickier because it expressly refers to territory, and I'm sure if you've done your research, you found the law review articles that talk about the travaux préparatoires that point out that the insertion of the word territory was intentional and was intended to limit the scope of application of the ICCPR. This is an issue that comes up often in the context of transnational corporations and human rights. As you know, there's a treaty potentially percolating up specifically on this issue, but for years, human rights advocates have tried to get the ICCPR obligations to encompass the conduct of transnational corporations, and human rights advocates will frequently say, oh, of course the TNC is subject to the jurisdiction of its state of incorporation. but we have to bear in mind who it is that has to be subject to the jurisdiction of the relevant state party and within the territory of the relevant state party. Of course, it's not the perpetrator, it's the victim. So whose rights must be respected and ensured under the ICCPR? The rights holder, those individuals who are both within the territory and subject to the jurisdiction of the state party. Of course, there's the Human Rights Committee's disjunctive conjunction, right? That it can be understood, the word "and" in this context can be understood to mean territory or jurisdiction. And the US position, of course, consistently is the ordinary meaning of the word "and" is "and," so both of these requirements need to be met. The Human Rights Committee's position is not as laughable as it may seem at first, and of course the ICJ has endorsed it as well. It's this idea that "and" can be an aggregator, not just to intersect the two categories, right? So if you envision the Venn diagram, category A, territory, category B, jurisdiction, tremendous overlap between these two, and that area of intersection, according to the US, would be "and," right, where these two circles intersect. And the Human Rights Committee, the ICJ, say no, "and" means everybody in category A and everybody in category B. So both of these categories of individual are protected by the obligations on states parties to respect and ensure rights. The privacy issue is, there's a bit of a potential dangerous path to go down, right? If you start talking about the agents of the respondent state and where they are actually doing the invasion of privacy, right? If they're actually examining the information in the territory of the respondent state, we'll say, okay, clearly they're in the territory of the respondent state. But again, who has to be within the territory and even or subject to the jurisdiction? It has to be the victim. And the victims, of course, were not within the territory of the respondent state. Unless you try to use that argument that there was jurisdiction over the radio station or TV station, and at least there were, when individual victims were within the premises, perhaps there was some exercise of jurisdiction over them. It also, this extraterritorial issue intersects interestingly with the freedom of expression issue, and in a couple of ways. First, you have the question of whether or not the respondent is responsible for shutting down the newspaper effectively in the applicant state. Well, you could say, well, to the extent it's interfering with their freedom of expression, they're situated outside the territory of the state party. They're situated theoretically outside the jurisdiction of the state party. So you then have to deal with the extraterritorial application question. Although an alternative route, and perhaps some of you picked up on this, is the freedom of expression is a two-way street. There's also the right to receive information, and an argument could be made that the people within the respondent state who are clearly within its territory subject to its jurisdiction, that there's an interference with their right to seek and receive information that's coming from this newspaper in the other state. But then you have another problem, right? There's potentially a standing issue, and you can come up with some sort of erga omnes argument, but it's tricky in this context. Another human rights issue that comes up, of course, is derogation, and this is something that's I'm very frequently discussing with my students, lots of interesting derogation issues in recent years, in light of the uprising in Libya, and then, of course, the Libyan government's tactics. Libya, a party, of course, to all of the major human rights treaties, no reservations, didn't lodge a derogation, but did they have to lodge a derogation? If it was a state of emergency and it was objectively evident and they at least declare a state of emergency, do they have to comply with the formal procedures? I would say yes, but unfortunately there's some jurisprudence to say that they don't actually have to comply with those formal procedures straight away. Another interesting aspect of the derogation issue, of course, is the discrimination issue, which is something that comes up in today's context quite often. I'm sure we all noticed that the grounds of prohibited discrimination in the derogation provision of the ICCPR are much more limited. In other words, there are forms of discrimination that are permitted in times of public emergency that are not normally permitted under the covenant, in particular, nationality and national origin-based discrimination. Probably on the minds of the drafters was the internment by the US of Japanese and Japanese Americans during World War II, right? Nationality-based discrimination, but that's okay as a measure of derogation under Article 4. Today, however, we would focus on the necessity prong. even though in principle that kind of discrimination is not prohibited as such, I think it would be much more difficult to show that it was necessary to engage in that kind of discrimination, which is a separate justification that has to be met in order to derogate. I think I'll wrap it up there and maybe come back to the state responsibility issue during questions if it comes up. Thank you.
So with that, maybe I'll just say that now hearing all the levels and depth of the kind of repeated to me of the question, I feel like I forgot to begin my comments with an apology. I am sorry. But with that, we're going to, I think as a point of clarification, I think if you want to start lining up behind the 2 mics in the room, you are more than welcome to. And feel free to ask any question you might have about the drafting of the case, about the questions presented, about names, about what did you have in mind, anything you want to ask, we'll do our best to assist.
Hello, my name is Elena Bailey. I'm from Wayne State in Michigan, the United States. I have a few questions. I will limit it to one, but if you would like to expound on what actually happened to Kafker, that would be great. In paragraph 32 of the compromise, we know that Professor Kafker was arrested, and I quote, allegedly in accordance with the Terrorism Act.
God.
Please, good sir, why did you put allegedly in there?
There's a reason why I started with an apology. Great question. First of all, let me even go before the allegedly. There's an argument that has been raised by team with regards to Kafker that I personally think is wrong, and that is the one on the warrant, whether or not there was a warrant. Initially, without drafting anything about this, we assumed that the answer would be yes, there was a warrant. And when we added a clarification that clarified specifically that that under the Terrorism Act, a warrant must be provided. Again, for us, it was presumed that that meant that that there was a warrant for Kafker's detention. And so to hear teams argue, nothing in the compromise says there was a warrant, for me was like at the stretch. And every time that the team argued that before me, I was like, are you sure, agent? I don't think that's in there. On the allegedly, and so I've actually raised the allegedly with Freddie, and I think we take diverging views because Freddie tends to give an actual, I say that it was a mistake, okay? Because one thing that I'm sure of is that we've not at any moment during our drafting of this ever conversed the allegedly. I don't recall why the allegedly was inserted. I've heard a lot of teams argue it. I personally, just in spite, raised the allegedly with a number of teams. But to be honest with you, in all truthfulness, I think that it was a mistake. But Freddie has a better, a more justification that would kind of relieve us from any responsibility.
So, Your Excellency, thank you so very much for this question. I would like to point you really more to the compromissory nature of what we submitted. There was quite a bit of back and forth as to whether we would do a true compromise as to which both sides would stipulate. Now, the problem, if you would have, in accordance with the Terrorism Act in the statement, then both sides would concede as to the domestic legality of the detention. If you put an allegedly in there, it permits the argument that the Terrorism Act itself was not complied with because there was no notification of the requisite points. And so to argue that, well, it was asserted by the arresting officer that this was under the Terrorism Act, but that, of course, we don't presume that the Terrorism Act would require detention in violation of international law. Therefore, in this case, it couldn't have been because there are requirements under international law that we would submit to you, Your Excellency, would need to be met under these circumstances, namely notification, namely compliance with the ICCPR. Obviously, the statute would have to be read consistently with human rights obligations, therefore allegedly in this case, because these were clearly, as you see from the rest of the compromise, not complied with. So, I mean, that's essentially the way that you would put the allegedly in there so that you don't get up against a judge such as myself who would say, if it doesn't say allegedly, why aren't you conceding in the compromise that this was in accordance with domestic law, and don't you have an obligation for it to be in compliance with domestic law, that it also be in compliance with international law? You're saying that the law is presumptively in violation of international law, and if so, don't we have problems with good faith presumptions, and don't we have a problem with, you not raising something at an earlier point, what have you. So the allegedly is there to give you more wiggle room. And the other side would say, well, yeah, of course we allege it was in accordance with the Terrorism Act, because it was. So you can play it in both directions. But because it's a compromise rather than a we say that it was in accordance with the Terrorism Act, to which both sides would have to agree, sometimes you have to sneak in and allegedly. So it didn't bother me as much.
It sure made the life of Riesland to argue notification a whole lot harder, though. So, and your life was hard to begin with. But yeah. So what we'll do, we'll take one question from each side. I think that would be the most fair. So.
Thank you, sir. Good morning. My name is Ken. I'm from China, and I'm going to ask a very rudimentary theoretical question about public international law. And just in case you guys think it's stupid, I'm not going to expose my university, so the disgrace will be on me. So my question is, every year the Jessup issue is going to be the pushing the boundaries, so there's no law consistent yet, so we have to discuss basically the Lotus case principle as well as the Northern Continental Shelf case was to raise a issue of customary international law. So this year we actually met the argument that because there is no state practice of each state is to penalize spy and espionage in the domestic law, so there have been a state practice and no opinion juris. But I'm just very curious about the committee's discussion, prior discussion on that issue, because according to my own understanding, that state practice mentioned in the Northern Continental Shelf case was about state practice that concerns the relationship between states instead of what they do domestically in their domestically to penalize an individual. And in most cases, and also during my research, I find, because I was trying to compare the spy activity with covert operations, black ops, that most states will deny that actually happened instead of arguing that they are permitted by law or not prohibited by law as stated in the Lotus case. So I'm just very curious about when the committee was preparing such kind of issues, what was your stance on that? Thank you.
So you're absolutely correct that when we say something like, this is literally the title of my dissertation, the law on espionage, it's very misleading. It assumes the existence of a law to cite to. However, in lieu of law, what is expected of teams, and I said this multiple times to teams that I judged, in lieu of law, what is expected of you to raise is state practice. But the kind of state practice I was referring to is not necessarily domestic legislation that criminalizes espionage. Instead, I was expecting teams to argue specific intelligence programs of the past. And some teams have done that effectively. So if you look at IV bells in the context of placing pods on cables in the ocean, or if you look at the Tempora program in the context of mass surveillance through cables, if you look at certain activities, as was the case in Australia v. East Timor, in the context of bugging certain rooms, or in the context of 1989 Russian bugging of the U.S. Embassy while it was being built, and there's so many of those. Right? Another example is the U.S. and the U.K.'s surveillance of every single member of the UN Security Council in the lead up to the Iraq War. Those were the kind of state practice that I was looking to hear. And Professor Michael Riesman, by the way, the name of the country, Riesland, is a token to him. Professor Michael Riesman likes to distinguish between the myth system and the operational code. So while we have a significant myth system here, Article 105, subsection 2 of the United Nations Charter the principles of territorial integrity, non-intervention on the one hand, or diplomatic immunity, diplomatic inviolability on the one hand, versus state practice that seems to be vast of state spying, which becomes the operational code. The law, Michael Reisman would argue, exists somewhere between these two dyads. And what was expected of teams is kind of figure out the way of how to argue where the law lies. And I think that it's challenging. It's not an easy task to do. It requires some forms of legal innovation and legal argumentation that it walks between the drops. And in that regard, I think that this year's problem posed a difficulty, which I'm happy that you're kind of noting was noticed, whether or not, and with the goal of this leading up to you kind of clarifying for yourselves, and hopefully once you write those articles and notes that I asked you to do, produce scholarship that helps clarify the answer to the question of what is the law on espionage, because I believe that a law is necessary here.
Just to speak to the more fundamental issue of how you formulate rules of customary international law, how you establish their existence, internal conduct, of course, can be relevant state practice. In fact, for human rights law and international criminal law, you're primarily looking at the internal conduct of states. The rub is with the opinio juris, right? Theft is criminalized everywhere. That doesn't mean theft is a violation of international law, right? So you establish that it's prohibited domestically, but then you have to show that that prohibition domestically is due to the belief that this is prohibited by international law, or that international law requires the criminalization of the conduct. So it certainly would qualify as practice, but it doesn't give you the opinio juris.
It's a good one.
Just briefly, you asked what the editorial committee did in this context. It brazenly facilitated this by going back through state practice. We had an email exchange going back to the original establishment of resident missions in the Renaissance and the practice of spying at that time, but who was supposed to do that? Was it supposed to be the resident or the non-resident? Were there any distinctions between the two? So we ran it really all the way down the rabbit hole. One other point, something that I think could be done in order to avoid some of the thorny problems with regard to internal conduct is don't argue it as custom, argue it as a general principle. To the extent that you argue it as a general principle, you get fit problems, whether or not it will be adopted as an international rule, even if you get the right number of states signing on, but you can sidestep some of the broader problems that you run into with custom. So if you see something where you like internal conduct, but you don't know how to make it custom, try it as a general principle. It might just work.
Thank you, sir.
Good morning. My name is Tan Haotian from China Youth University of Political Studies. I am interested in your progress of drafting the compromise. I'm curious that how did you combine your ideas together and made such a fluent story? Thank you.
Well, the original draft of this compromise had a subpopulation called the Zabudians, and they were attempting a secession in Estonia. That sounded way too much like last year's compromise, and at the wise advice of the committee, was very vocal about that. This was quickly turned off. And the story goes, and Freddie loves this one, is that I was watching, I'm not sure how many of you are familiar with the show Elementary. I was watching Elementary. The last season of Elementary has 2 episodes in a row, one involving eco-terrorism and the other involving the decline in bee population due to colony collapse disorder. So in my desperate attempt to find something to argue that would justify surveillance, I turned to the only show I watched at the time. And that led to that part of the compromise being drafted. Surprisingly, the majority of the main issues were always there. So the surveillance was there, the broadcasting treaty was there, the cyber attack was there. What was missing was QP3. Originally, QP3 was all about the extradition of Frost and the legality of the extradition. By the way, it was not called Frost at the time. I forgot what the original name was. We had various kind of, it was way too close. It was Eddie, obviously it's right, Snowden, right? But it was Eddie something. That was too close to home. But arguably and correctly so, there was very little to argue an extradition in line of both state practice and the political offense exception and so on. So we didn't find that to be a very interesting topic. I was suggested by the committee to think about kind of the field of derogations. I remember that was one of the comments that I was given. And I worked with Professor David Kretschmer at Hebrew University, was a former expert member of the UN Human Rights Committee, and we worked on an exam question, the content of which is exactly the same as the question in QP3. So I don't think that any of the students who participated in that class did Jessup this year, but had they done so, they would have had the answers already for them.
To add to that, the placing of a pod on a cable features in the, immediately next episode of Elementary. So under those circumstances, the person who placed the pod there was not the person who was initially suspected. So we would have accepted as a factual answer that, well, in addition to the compromise, the series Elementary would show you that just because a pod is there, it doesn't mean that whom you suspect actually placed it there.
It's a shame you didn't bring up Elementary in your argumentation.
Thank you, and good morning. And I want to thank the author and the committee for an extremely interesting and difficult problem. You and I discussed briefly on Sunday about the enforceability of the ICCPR. Now we have an embarrassment of riches, and maybe we can discuss this a little more. Looking at the four corners of the ICCPR and the Travaux Préparatoires, is it meant to be enforceable at all, state to state? And if it is enforceable even by individuals, is there any other appropriate forum for enforcement than the domestic courts of the signatory state?
Right, so this was a very embarrassing moment at the beginning of the week where I was asked this question and at the time was startled by it. I think I have a better response to it now. I'm not sure that it's the great one. I would appreciate Professor's comments on this as well. One thing that I think is relevant to note is the extent to which we have to rely on direct enforcement in this context, given that the request to the court is only of a declaratory judgment, and in particularly, one can make the argument that what the court is asked to do is really interpret the wording of the ICCPR and whether or not a potential violation of Article 17 in the context of the privacy, Article 9 in the context of the detention had occurred. Surely we then move on to other more substantive remedies in this question, like the release of Kafka or the cessation of programs, and that becomes more of an enforcement argument. So I tend to, after discussing, I tend to agree with you that initially it's interesting the extent, I mean, the ICJ has in the past relied on the ICCPR. If I look at Diallo, it relied on the ICCPR to provide compensation, and so we do have examples to rely on to justify this, but once again, if you have better views than mine.
Yeah, I would just say that treaties don't exist in a vacuum. Of course, you have the law of state responsibility, the secondary rules of international law, which apply across all of the primary rules, right? You might argue that the ICCPR, to the extent it entails specific dispute settlement mechanisms, derogates from those general rules, but I would say that's the case only if there's a conflict. And the mechanisms provided for in the ICCPR don't seem to me to conflict with the more general rules of state responsibility. In other words, you could still invoke the responsibility of the offending state, and you have looser rules in terms of injured state when it comes to erga omnes obligations, and that's expressly provided for in the Articles on State Responsibility. So they're contemplating human rights obligations, and demanding reparation, not just in the interest of the injured state, but also in the interest of the third-party beneficiary, who'd be the individual human being. So I would say, to the extent that the law of state responsibility was written with human rights obligations in mind, among of course, all the other primary rules of international law, but there are certain provisions that are tailored to human rights obligations. I would say certainly that that regime would apply for human rights treaties as well.
Thank you.
Hello, I'm Kate. I'm from Belarusian State University, and my question concerns the first submission of the applicant. And it is saying that the mass surveillance programs over Estonian nationals and public figures violated some obligations of recent oath to Estonia. So my question is, was it the intention to put mass surveillance programs in this passage? Because the Verismo program is undoubtedly mass, but Carmen program is not mass at all, and at least of the view of our team. So should we take those two programs together and call them mass, or deal with it separately, like mass surveillance, Verismo, and espionage, Carmen?
In the context of the word mass, so first of all, I agree. I tend to agree with you completely. I think that Verismo is a classic mass surveillance program, whereas Carmen is a classic targeted program. With that being said, the volume of people targeted by Carmen politically might qualify as mass. We also don't know, in theory, for when Estonia is drafting this paragraph, we don't that pleading. Estonia doesn't know if there exist other programs that might be provided for in the other documents leaked by Frost. With that being said, I think that when we drafted the word mass surveillance, for me at least, it was predominantly to whetten the appetite and to make sure that you look at the vastness of kind of the practice and law emerging on mass surveillance programs as a whole. And didn't make we could have said violated the mass surveillance program and the non-mass surveillance program, but there's also lingering which is already one of the longest pleadings on there. I don't know if Freddie has further.
I think there is a sense in which the Carmen program would again come up in QP2, because part of the reason that you could argue that the seizure and forfeiture of the VOR station and equipment was not precluded by the treaty is that that program itself was unlawful and contrary to the activities in Article 2, and then run that analysis. So to the extent that my recollection was, in a way, that we really focused on that much more in the context of QP2, but that when teams brought it into the context of QP1, I was perfectly happy to accept that as, well, that's a reasonable reading of what is going on. But to a certain extent, I do think that we were more focused that we essentially had one for each of them.
And there's no question that there's far more law to rely on in the context of mass surveillance and the recent jurisprudence of the European Court of Human Rights on mass surveillance programs and Article 17 of the ICCPR, and most teams have indeed kind of focused or zoomed in their argumentation under QP1 on these issues indeed. So I think that's also a valid argument.
Thank you.
Hello there. Mykola Yurla from National Law University, Kharkiv, Ukraine. Oh, thanks again for a fantastic compromise. And the question that I would like to specifically address is the issue of admissibility of evidence. So what did you really expect there? Was it the authenticity argument or the illicit obtainment? I mean, the fruits of the poisonous doctrine or the good faith and fair dealings?
Touching on a very shaky ground there. So it's a good thing that Stephen Schneebaum is here. Is truly, if there is a question that you want to kind of pose your attention to, it's on that part of QP1. That was Stephen Schneebaum was leading the charge in the justification for including that section. Let me just give you. There was a long debate on this issue. So let me just briefly touch on the reason why we included this, and then what kind of arguments we thought of this bringing up. But the reason was a narrative reason. It was argued debatingly, but it was argued maybe correctly by the committee, that Riesland would never have agreed to bring this case before the ICJ had it not included a provision within the compromise, within the special agreement, saying that this is without prejudice to our arguments concerning the admissibility or lack thereof of the documents. My concern was that that could potentially derail conversations by students on what I consider to be the primary focus of this year's case, which is the legality of espionage. So in fact, once the bench memorandum gets published, you'll see that there is a clarification in bold to judges to not go for more than X amount of minutes on admissibility, which, at the end of the day, judges will be judges, and so issues of admissibility sometimes went as far as 8 or 9 or 10 minutes, but that's just how things are. I agree that the admissibility issue is a valid one from a narrative perspective, and if you're asking me what are the most, I think that it is, given the way the ICJ's jurisprudence has been on this issue and the leniency to accept evidence, I think that it is a relatively easy one to answer for Estonia and makes it, and I think that the only really valid, so I don't think authenticity and credibility are strong enough personally, and I will also say that there's a reason why we included those divers, or at least when I pushed those divers in the clarification was in part to make sure that you can't really argue that we don't know, we know these documents say what they say is correct. I think it is a far more interesting argument to argue the legitimacy of the court, and by admitting these will legitimize whistleblowing. I think there is a far interesting argument. You can make the illicitly obtained argument. I think that if you want to go that path, you'll have to argue that Estonia is somehow complicit in the illegality through an Article 11 ILC articles argument of attribution of Frost activities. But, yeah.
So let me step back for a moment. Part of what you do in real litigation is you don't win with every argument that you make. You set up other arguments. You're signaling, in this case, to the court that there is a problem and that you are contesting that this is the story. There are documents out there that are a significant hindrance to you in terms of what you'd want to tell the court, and so you raise an objection. In this case, I would presume that everybody knows that the objection will be lost, but that the effect of it is to deal with the probative value of that evidence. Now, I think authenticity doesn't work, despite the fact that we, for the longest time, had a back and forth that authenticity would be something that would be very hard to stipulate to. And so the argument could run something like this. Look, these are documents that were not released by us, and they are obviously selective. The problem that you run into when you look at selective documents like this is that you have one side without us being able to complete the evidentiary picture, because we will not disclose to you documents as to which there are national security implications, nor could you order us to do so. So under these circumstances, we are now required to fight without equality of arms, because there are documents out there that ought not be before you that we cannot answer to without impugning our own national security interest. Conceding, however, that for purposes of the current argument, we will look at these documents because the information from them has been included in the compromise, let me move on. That is, you've signaled now, you have incomplete information here, which means that whenever somebody wants to draw an inference from the compromise, you can say, no. No inferences here, because you have incomplete evidence and we cannot complete the picture. So it's essentially a tool that you would use in actual litigation when you're, with your back against the wall in an evidentiary context, that you don't want to win evidence. You want to signal something about your case. And I think, as a general rule, when you actually litigate, everything is about evidence. So I thought it was a very good thing that we exposed you to that, and that there are evidentiary issues that you're going to run into, and that you don't use the evidentiary fight to win the evidentiary fight. You use the evidentiary fight to win the case. So
Yeah,
that,
and one of the greatest things that this allowed, incidentally, we'd never thought of it when we drafted, was they allowed judges in QP3 to then rely on what the applicant said or your co-agent said in QP1, that either the documents are authentic and reliable or not authentic and not reliable, to then say to Islamic teams, well, your co-agent said that it's authentic and reliable, that it's not authentic and non-reliable. How can you rely on these documents to justify the detention of Kafka and vice versa? Your co-agent is well, it's authentic and reliable, therefore we have to rely on what is said there, that he is connected to the hive. And as you've guessed by now, judges have a tendency to really enjoy the moments where we can kind of challenge Speaker 2 about things that Speaker 1 said. It's kind of good joy there. We have around 25, we're going to continue this around 12:15. So maybe 20 more minutes. So we'll try to limit our answers and be quick, because I see there's a lot of questions more to go.
Thank you very much.
Yeah, why don't we do 2 questions? So we'll get 2 questions at a time.
Well, my name is Florian. I'm one of the coaches from Munich. And first of all, like, we as coaches really enjoyed this year's problem, because with some of the less traditional problems, we started at the same level of knowledge with our students, and it was kind of a challenge to not let them know or to maintain our credibility throughout this this time. So that was challenging, but also we really enjoyed that, like learning with the students. My question would be, I'm going to use admissibility, but just as an example, because it's a more general question. With the admissibility, we thought that, for example, in the German national rounds, judges just didn't want to talk about it, because in some jurisdictions, especially where there's no jury trial, admissibility is not such a big problem. It's basically everything's admissible, and then the judge has to decide, right? And so these, like, my question would be, do you think about like how problems, I mean, it's an international law problem, and of course we look at the ICJ, but how different legal traditions, how the problem will be interpreted from a different background? Thank you.
Hi, good afternoon. My name is Saif, and I'm from Malaysia. I have a quick comment and 2 questions. The comment, I do agree, the compromise this year, what makes it really difficult is that the issues are really broad. I would open up our opponent's memorial, and you would see that each team would argue a particular issue so differently. To the question, the first question is on admissibility. Did you in any way intend for extradition to be an argument in admissibility? You said earlier that Estonia played a part in the illegality, so the refusal of Estonia to extradite Frost and the documents back to Riesland, did you ever envisage that as a ground to deny Estonia to rely on them on the basis of extirpe doctrine? And the second issue goes to the issue 2. Did you in any way intend for invalidation to be an argument? Because we did have certain materials in the second batch that do indicate the argument on fraud, when it's clearly evident that Estonia did not fulfill the notification requirements. And some teams did argue that, so we were just wondering if that's what you intended. Thank you.
Very briefly on the first point, I think that one of the interesting things in the Jessup is the way traditions of law in different countries effectuate the kind of legal argumentation raised, but also the style of argumentation of certain teams. And that's part of the joy of what the Jessup is all about. I can tell you in a different context that I've heard arguments by European teams relying heavily on data protection laws in the EU as a basis to establish certain customary or general principle rules. I think that there's something we should generally support. With that being said, there's rules on what are the sources of international law. The expectation is that students rely on 38 of this court statute and therefore rely on the traditional sources of international law, and to the extent that they want to rely on domestic legislation, they can do so through a general principle or through domestic jurisdictions coming up through 38(1)(d). And we've seen some teams argue that on admissibility. I'll give you one example. One thing that initially I didn't think about at all. I've heard a lot of American teams relying on American court rulings with regards to the nature of television stations as being of commercial nature, and I thought that was a creative argument to justify the state immunity, alleged state immunity violations. So yes. On extradition, very briefly, yes. In the bench, there is a reference to Article 11, and there is a potential argument to be made on attribution. So yes. On invalidation, the Permanent Court of Arbitration is supposed to rule at some point on what happened in Australia and East Timor. My guess that if they do, it will be secret and closed, and so you'll never read what they said. But what we're looking at, the problem that teams have with fraud is that the issue has never been adjudicated sufficiently for you to rely on anything. When we drafted this part, we didn't know where the PCA judgment might go, and I think that part of kind of my initial notion in the drafting was to include this as a potential argument, but not know where it might go at the end. So that's my 2 points.
First of all, grüß Gott. Then our editorial committee has people from essentially the major legal traditions. So as part of the editorial committee's work, we do take that into account. When it comes to issues of admissibility of evidence in particular, I'm currently writing, co-authoring a book on evidence in international, well, investor-state arbitration, but in international law, and people keep telling me that there are no rules. Having practiced a significant period of time, I can tell you there are rules. It's just that civilians don't like to say that there are rules, they still apply them. So there's sort of this myth out there that there are no exclusionary rules of evidence. There are. And it's just that we talk about them differently in a civilian context. So just on that, I would say, yes, we do take that into account. And with regard to this particular battle, I just keep battling my civilian brethren and say, no, you do have these rules. You just don't call them that. And with regard to invalidation, you could make that argument, but you have reasonably straightforward arguments of just reading the treaty. So I don't think you need to go there, but if there would have been a development that made that attractive, you could have gone there, if that makes sense.
I'm getting various time signals, so we'll now take 4 questions, which is going to increase the number. Yeah.
Yeah, I'm Phillip, also from Germany, actually. I'm Florian's co-coach. My question would go to QP1, namely the SSBA, prohibiting surveillance involving communications with Icelandic nationals involved. And we were wondering how that affects the VRISMA program, and if it affects the VRISMA program, what the respondent would answer to the unlawful argument.
My name is Molly Thomas. I'm from the University of Queensland. My question goes to pleading 3. What was the inspiration for the honey contamination plot facts? And was it at all influenced by the Harvard Research Draft Convention on Jurisdiction with Respect to Crime, the specific section on attempts in that respect?
Hello, I'm James from the Australian National University. Good to see you again, Saf. I'm interested in the approach you would take to your book on espionage. Do you think that there are customary international laws and exceptions specifically for espionage and surveillance, or do you think that these concepts have to be filtered through human rights law or first principles of sovereignty?
Thank you.
Hello, my name is Dmitry. I'm from Yaroslav Device National University of Ukraine, and I was wondering about the fact that you several times pointed out the issue of friendship. So firstly, in paragraph 7 of the compromise, when it was yet another milestone for this warmest relations between our nations. Secondly, in paragraph 28, that President Hale stated that France did not spy on France. And finally, in the Broadcasting Treaty Preamble, paragraph A. So we were wondering how could we use it for interpretation, and we were really developing the argument concerning interpretation of the terms of the treaty, namely functions, in light of the friendship relations, of the friendship purpose, and to declare them like non-performed as they were contrary to the friendship hiding espionage program.
A lot of questions. SSBA, Icelandic nationals. 2 arguments there. One is narrative-wise, every domestic legislation on surveillance, foreign surveillance legislation I'm familiar with makes an exception to domestic surveillance, and just from a narrative point of view, we thought it would be important. I did expect teams to raise non-discrimination claims on regards to foreign versus domestic, and more broadly, I expected teams to really hit on the notion that human right to privacy is a universal right as opposed to a state right. With that being said, I've heard teams argue effectively, or presumably effectively, that we should make distinctions on the level of oversight and on the level of minimization procedures for domestic versus foreign surveillance. I don't know if there's a justification for it in law. There's certainly a justification for it in state practice. In reality, states do it all the time, making a justification there through their own domestic legislation, but I don't know if that's a smart argument or not. On the contamination plot, no, I didn't rely on that. With that being said, I was thinking of terrorist activities that can relate to eco stuff and relate to bees. And so the first thing that came to me, why not contaminate honey? And so, I don't know if that's a good enough answer, but that was the logic behind that. On a very great question. Thank you for asking it. I don't prescribe to the notion that, as Professor Simon Chesterman likes to say, who is, by the way, the name behind Chester from Chester and Walsingham, likes to say that the espionage is in the shadow of the law, is a legal penumbra. I don't believe that it is a legal penumbra. What I try to do it's not yet a book, it's a dissertation that is pages of which has not been written yet. So what I try to do in this foreseeable dissertation is to look at every subfield of international law, more than 15 of them, and identify rules on intelligence. And in reality, international law has a lot to say on what intelligence can and cannot do, from outer space to the law of the sea. And I think that no one has actually put all of those rules together in one treatises, and that was what the book to say. And if you want the full answer, you'll have to read my dissertation in 3 years' time when it's written. Finally, on friendship, what we were relying on for me is rules of comedy, and I did expect students to try to come up potentially, arguably, with some kinds of an argument under a general principle or under the UNGA resolution on friendly relations as a potential argument on espionage. This was originally, I don't know the extent to which one can argue that effectively. Freddie will follow me, but I keep seeing times that we need to stop. So what we'll do is, after we'll make our final observations here, is that everyone else still in this line, please don't disperse. Come here, right here in front of us, and we'll answer every single one of your questions. I don't want to leave a single question. No. Oh, outside. Sorry, right. They're setting up here for the judge. So we'll go outside, but please come, because I want to answer every single one of your questions.
The only thing that I'd say is on friendship, which is yes, that was intended because there's the teleology, the teleological interpretation of the treaty that you could use to that effect. And you could then use the compromise to support the teleology, not just with facts in the treaty, in treaty context, but also object and purpose outside. And I don't have anything on the other one, so I think we can make people happy. Yeah.
Just very quickly on the friendship issue, it just struck me, the references to the friendly relationship, that this case would never go to the ICJ. And that, in fact, there would be such an interest in restoring the relationship. It would be dealt with quietly and the issues would be finessed away, unless one state basically knew they were in the wrong and they just needed political cover before a domestic audience. So they'd have to lose before the ICJ to do stuff that would be unpopular domestically.
And let me end with one thing. David Cornwell, John LeCoeur wrote in The Secret Pilgrim in 1992 the following. He said, "For as long as rouges become leaders, we shall spy. For as long as there are bullies and liars and madmen in the world, we shall spy. For as long as nations compete and politicians deceive and tyrants launch conquest and consumers needs resources and the homeless look for land and the hungry for food and the rich for access, your chosen profession, intelligence analysts, is perfectly secure." Part of what this Jessup year is all about, part of what I strongly am a great believer of, is the need for us to reconceive our notions about what rule is for law in the practice of intelligence agencies, which have become wellsprings of power in our society. I strongly, once again, going back to my original comments, put a responsibility on you, the newest generation of international legal scholars in the world, to rethink and reconsider these legal penumbra, this legal limbo, to the extent that it really is or should be exactly that. And once again, thank you so much for bringing this case to life. It's been brilliant.